Hi, I'm Eleanor from the Online Letting Agents, and I'm here today to talk to you about the Renters' Rights Bill. Now, first thing to mention is this is being recorded on the 21st of February. The Renters' Rights Bill isn't yet in force. It hasn't received final royal assent yet. We're expecting that to come in April with a due date for the actual bill to be enacted to be decided. We're expecting that to come in. Estimates are somewhere between July and October. My personal thoughts are it's more likely to be towards October time, which will give everybody involved in the private rented sector time to put in place whatever measures they need to, ready for the bill to come in. So to start with the bill, tenancy agreements. All tenancy agreements will become periodic. There will be no such thing as an assured short hold tenancy under the Renters' Rights Bill. All tenancy agreements will be assured tenancies and periodic from the start. If you have a fixed term tenancy right now, or when the bill comes into force, that will automatically become periodic straight away. Because it's a periodic tenancy, that does mean a tenant will be able to serve notice to leave. The notice periods for tenants will be increased. It will be doubled to 2 months notice, 2 calendar months notice, I should point out. What a lot of landlords worry about is that means a tenant will move in, serve notice, leave, and every 2 months they're going to have a role of having to find new tenants. But don't be too worried about that. On average, tenancies last for around about 2 years, and there's no reason to believe that all of a sudden with the Renters' Rights Bill, suddenly you'll end up with 2 months tenancies. What it does mean is that if a tenant moves into a property and they find it to be substandard, they will be able to serve notice to leave. Notice periods for landlords are also changing. They're also basically doubling. So where a landlord currently might give 2 months notice, they will now need to give 4 months notice. And just going on to serving notice, there will be an abolition of the Section 21 notice that will no longer exist. All you will have now is a Section 8 notice. To explain the way Section 8 notices work, when you serve a Section 8 notice, you always have to give a tenant a reason why you're asking them to leave. Those reasons are called grounds, and those grounds are predefined in a list. And essentially, you, in your notice, will list all of the grounds you are giving your tenant for why you want them to leave. Those grounds are divided into mandatory grounds and discretionary grounds. The difference between the two is if you serve notice and your tenant doesn't leave and you have to go to court for a possession order, if you have a mandatory ground, it is mandatory for a judge to give you a possession order. If you have a discretionary ground, it's at the judge's discretion. This is why we would only ever advise you go to court with a Section 8 notice if you have a mandatory ground. With the Renters' Rights Bill, they will be extending the grounds for possession, and there are a few in there that are worth noting. Ground 1, which is that you are moving back in, or a close family member is moving back in. Ground 1A, that you are selling the property. So both of those come with a 4-month notice period. Both of those also come with 12 months protection for the tenants, in so much as you can't end their tenancy within the first 12 months. So if you start a new tenancy and it's not working out with the tenants, you won't be able to serve them notice on either of those 2 grounds within the first 12 months, or rather end their tenancy within the first 12 months. Bear also in mind that if you use one of those grounds, you won't be permitted to re-let the property, either advertise it for let or sign a tenancy with a new tenant for let within 12 months of the date that you've given the tenants to leave in that notice period. So if you are going to use one of those grounds, you really need to carefully consider what your future plans are and that you actually are selling, or that you actually are going to be moving back in for at least a year. Another one of the grounds for possession which is changing is rent arrears. Currently you can serve a Section 8 notice on the basis of rent arrears if they're 2 months in arrears and then you give two weeks notice. That's going to be increased to 3 months arrears, and then you'll need to give 4 weeks notice. So that leaves you with a bit of a longer period to be without rent before you can even start the process of evicting tenants. Another clause or another ground there is for student landlords. So a student landlord, provided they are renting to students, and in every sense it is a student let, so the intention was to rent to students, the people you rent to are students, you will be able to serve them ground 4, which is ground 4A, which is a 4-month notice to ask the tenants to leave. The notice can end the tenancy anywhere between June and September, but it must be on a student let that you're asking students to leave, essentially ready for the next round of students to come in. One of the requirements of this ground is that you must have given the tenants forewarning. That will no doubt be through the tenancy agreement. There'll be a clause in there to say about this student ground, and you must have signed that tenancy agreement within 6 months of the tenancy start date, which does mean for those student landlords who maybe sign a contract in December, January, February, now those dates are going to be pushed out. If you want your tenancy to start in September, I believe it would then be May, June time that you'd need to sign the contract in order to be able to use ground 4A in the future. The next one is rent increases. So rent increases are changing, but not drastically. Currently, you can increase a rent via a tenancy renewal or via a Section 13 notice or an agreement in writing with the tenants. In the future, you'll have to use a Section 13 notice. That will be the only way to increase the rent. So that's not a big scary one. What is slightly concerning is that a tenant, if they are unhappy with the amount of rent being asked for, will be able to apply to the first tier tribunal. Now, they can do that already, but the difference will now come that the first tier tribunal can only increase the rent to as much as the landlord is asking for and no more, and they will not backdate any rent increase. They will set the date at the tribunal to what date the new rent will come in from, and it could be the date of the tribunal, or it could be anything up to 2 months in the future. My thoughts are a lot of tribunals might end up giving a date for the rent increase being 2 months in the future, which would give the tenant time to serve notice if they want to leave before that rent increase comes in. So that's slightly worrying, but like I said at the beginning, we're yet to have the final details of the bill, so there might be some changes that come with that. There's also a change in terms of marketing and what they refer to as rental bidding. So quite often we'll have a situation where you have multiple people who want to take a property, and someone, or maybe multiple groups, will come in with an over asking price offer. In the future, when the renters' rights comes in, that will be prohibited. You will not be able to accept rent in excess of the asking rent. So you need to make sure that the rent that you are asking for is what you're expecting to get or above, so that if you do receive an offer, it's somewhere up to what you're asking for, because you will not be able to accept a penny over. Whilst we're on the topic of rent, you will also find that there are differences in terms of taking rent in advance. Rent in advance will be a thing of the past. You will not be able to accept rent in advance at all, regardless of them being an overseas student who wants to pay 12 months in advance because they don't have a UK guarantor, or someone who can't pass the references through the conventional means and is offered to pay 6 or 12 months rent in advance. You will not be able to do that. The only rent in advance you will be able to take is the first month's rent, and you will only be able to take that after the tenancy agreement has been signed. No other rent in advance can be taken at all. Tenants will also have strengthened rights to request a pet. Any request from a tenant to keep a pet cannot be unreasonably refused. Now, there is no definition currently of what is unreasonable, but the suggestion is that it wouldn't be unreasonable for a landlord to say, no, you can't keep a pet, if they, for example, have a superior landlord, so say they're a leasehold and they are subject to the freeholder agreement, which says that it's a no pet building and therefore they can't have pets in the building. That's an easy answer for the landlord to say no. But if you've got a nice little 2-bed semi, there's no real reason why you should say no to a cat or a dog. You also won't be able to discriminate against tenants in receipt of benefits or tenants with children. That doesn't mean to say that you don't have a choice in who you rent to. You can still say that you only want to rent to tenants who can pass the reference checks. There might be insurance implications for you, for example, if a tenant isn't able to pass the reference checks. You might also, for example, have a 1-bedroom flat that just isn't sizable enough for a family of 3 or 4 to live in. So in those situations, it would be reasonable for you to decline their interest. Something else for landlords to do, and this is going to cost landlords money, they will need to sign up to a landlord property, private rented sector landlord ombudsman. The ombudsman is there to police landlords. It's not for landlords to complain about tenants, but it is there for tenants to complain about landlords. You will need to register on the database before you can let a property. You will also need to keep your membership in place. You'll need to have the membership before you rent your property, before you even advertise it to let, and all the way through till after you cease being a landlord, because a tenant will be able to register a complaint against you from the moment they submit their initial inquiry via the agent, all the way through to after the tenancy has ended. I believe it's up to 2 years that they can still register a complaint against you. There will also be a private rented sector database for landlords to join. This seems to be more about local councils and their policing. You will need to register yourself and all of your rental properties on there. That will be a publicly available database. We're yet to see or understand what information will be published on there about a landlord. My thoughts are that there will be some protection for landlords. I don't expect it to have your phone number, email address, home address on there, but it may well say who is the owner of which properties, and potentially things like the licenses that you have for those properties, and maybe even any sort of enforcement action that's been taken against you or complaints made against you. The idea of the database is that tenants can access it and make an informed decision about which landlords they're renting from and which properties they're renting. So it would seem relevant that some of that information was published there. Lastly, and this shouldn't concern good landlords with good properties, there will be a decent home standard, and they'll be extending Awaabs law from the social sector to the private rented sector. So essentially this means that landlords will be under more scrutiny, and there will be more powers for enforcement if landlords are found to be providing homes that are substandard in terms of health and safety, mould, damp, excess cold, things like that for their tenants. Lastly, penalties. So I mentioned about landlords not being able to re-let for 12 months after they've evicted a tenant on ground 1 or ground 1A. In general, as a rule of thumb, penalties are looking like rent repayment orders of up to 2 years rent, fines of anywhere between £7,000 per breach and up to £40,000. The £40,000 you would be looking at repeated breaches or very serious breaches. That wouldn't be just oh, I didn't register on the database until after my tenant moved in. But for serious breaches, you can be looking up to £40,000 or criminal prosecution. So it really is important for all landlords to make sure they are on top of the Renters' Rights Bill and understand exactly what they need to be doing to make sure that they are compliant. I hope you've enjoyed this. I hope you found it informative. If you did, hit the like and subscribe button. If you have any questions, if you pop them in the comments below, I will do my best to answer each and every one of you in the next video session that we have. You'll also find our contact details down there in the comments section. Thanks for listening. Bye.